Advertising and solicitation. The rules of professional conduct regarding advertising have evolved in the past few decades in response to the U.S. Supreme Court decisions regarding speech. In the ancient days when I went to law school, advertising was prohibited and ethics rules enforced behavior in light of the bar's desire for attorneys to appear dignified. Today, dignity is out the window. This is the information age, and consumer protection is the order of the day. Today, legal advertising and solicitation are governed by the need to avoid false and misleading communications and the need to avoid overreaching. A bit of history may be helpful as we explore Rules 7.1 through 7.6. In the 1970s, two lawyers were leaving the legal service office to set up a private practice to serve those of modest means. They advertised their services and prices, simple divorce for X dollars, and so on, in a simple print ad. The Bar of Arizona disciplined them for violating the rules of professional responsibility. In the 1977 case of Bates v. Arizona, the U.S. Supreme Court held that lawyer advertising was constitutionally protected commercial speech, and a total ban on attorney advertising was unconstitutional. The case decided that discipline for this advertising of simple prices for particular services was not permitted. The court discussed the historical justifications for prohibiting attorney advertising, that there was an adverse effect on professionalism, that ads were inherently misleading, that they stirred up litigation, that ads increased overhead costs, that there was an adverse effect on quality if price was advertised, and the difficulty of enforcement. In some cases, the court held that the rationale was not a valid justification to suppress speech. For example, that ads might stir up litigation was not a justification for prohibiting advertising. The court held that advertising was not inherently misleading. With other issues, the concern was not enough to entirely suppress speech. Nevertheless, the court stated that there could be reasonable regulation of advertising and solicitation. The bar could prohibit false or misleading ads. There could be regulations as to reasonable time, manner, and place of advertising. Some years later, the U.S. Supreme Court again considered advertising in the case of Zauderer versus the Office of Disciplinary Counsel in 1985. In that case, the attorney had printed a picture of the Dalkon Shield in a newspaper ad, stating that women could be injured by this contraceptive device, and offering to sue the manufacturer on their behalf. The court held that the attorney could not be disciplined for a, quote, undignified ad, that there was no state interest in that. Rather, this speech was informative and could not be prohibited. Also, the bar could not discipline this lawyer for fears that the ad would stir up litigation. There was no state interest in denying access to justice for parties who had been wronged. The one area in which the court upheld discipline was with regard to a misleading feature of the ad. It had stated that there would be, quote, no legal fees, close quote, if the case was not successful. Yet the attorney would charge the client costs. The client could be misled by the no legal fees statement. These opinions have left us with Rule 7.1, which states that the lawyer may not make false or misleading communications about her services. The rule defines false or misleading as a statement that contains material misrepresentation of fact or law, or that omits a fact necessary to make the statement as a whole not materially misleading. Comment 2 points out that even a truthful statement might be misleading if there is a substantial likelihood that it will lead a reasonable person to reach a conclusion about the lawyer or his services for which there is no reasonable factual foundation. Thus, a statement about the lawyer's prior victories might be misleading if it would lead reasonable people to unjustified expectations, as Comment 3 states. Unsubstantiated comparisons with other lawyers might be misleading in this way. However, if the ad includes an appropriate disclaimer, that may cure the problem of creating unjustified expectations. Note that Rule 7.1 deals with all communications about the lawyer or her services, not just advertising. 7.2 deals specifically with advertising. 7.2a expressly permits a lawyer to advertise through written, recorded, or electronic communications. And 7.2c requires that any such ad include the name and office address of at least one lawyer or law firm responsible for the ad's content. Rule 7.2b prohibits giving anything of value to a person for recommending the lawyer's services. This prohibits paying others for channeling work to the lawyer. It prohibits finder fees. It prohibits paying EMTs or tow truck drivers for passing out the lawyer's card. It prohibits giving gifts to persons who channel the work to a lawyer. It also prohibits reciprocal referral agreements between different law firms or between a law firm and allied professionals, like chiropractors or financial advisors, unless the reciprocal referral agreement is not exclusive and the client is informed of the existence and nature of the agreement. However, Rule 7.2b does not prohibit paying the usual costs for advertising, nor does it prohibit the lawyer from paying the usual charges of a legal service plan or a non-profit referral service approved by the proper regulatory agent. Nor does it prohibit buying a practice, as is permitted by Rule 1.17. Let us next turn to solicitation. Again, historically, personal solicitation, as in ambulance chasing, has been prohibited. In 1978, the U.S. Supreme Court had an opportunity to address in-person solicitation in two cases. The first, Orlick v. Ohio State Bar, involved an attorney who had been approached by parents of a young lady who had been in an auto accident. He not only advised this young lady, the driver of the car, but also visited her passenger, who was hospitalized, and had the passenger sign a retainer agreement with a contingency fee even while she was hospitalized. When the young ladies attempted to dismiss the lawyer, he sued to recover his fee. Ultimately, the Ohio State Bar brought a disciplinary case against the lawyer based on his in-person solicitation. The U.S. Supreme Court held that the bar may prophylactically prohibit in-person solicitation to avoid the overreaching which is inherent in that sort of contact. The court reasoned that the state has a compelling interest in preventing solicitation that involves fraud, undue influence, or intimidation. And lawyers with oral advocacy skills are particularly suspect for that sort of wrong. The second case was In Re Primus. There, the attorney had held a meeting with a woman welfare recipient who had been sterilized, allegedly as a condition to continue receiving government benefits. After the meeting, the attorney wrote the woman a letter stating that she, through the ACLU, would be willing to represent the woman in a class action suit. The attorney was disciplined for this solicitation. In this case, the Supreme Court overturned the discipline, holding that the attorney's communications were constitutionally protected political speech. The way in which these two different holdings live on is through Rule 7.3. That rule prohibits in-person solicitation when a significant motive is the attorney's pecuniary gain. Not only is face-to-face solicitation for money prohibited, but so is real-time telephone or electronic contact. The only exception to in-person solicitation for money is if the prospective client is another attorney or the prospective client has a family, close personal, or prior professional relationship with the attorney. The comments make clear that there is potential for abuse and overreaching whenever an attorney is personally soliciting a client. The situation is fraught with the possibility of undue influence, intimidation, and overreaching. The exceptions are made for lawyers, former clients, and close family or friends because it is far less likely the attorney would engage in abusive practices with them. Comment 5 also points out that the likelihood of abuse is lessened when the lawyer does not have pecuniary gain as a motive, and that the rule does not prohibit the lawyer from participating in constitutionally protected activities or public or charitable legal service organizations or bona fide political organizations. Rule 7.3b prohibits coercion, duress, or harassment in any solicitation that is otherwise permitted. Thus, the lawyer may not solicit employment from a prospective client by any means, written, recorded, or in person, if the prospective client has made known a desire not to be solicited, or if the solicitation involves coercion, duress, or harassment. Rule 7.3c requires that any written or recorded solicitation include the words advertising material. The rule regarding written solicitation, often referred to as direct mail, also evolved from a U.S. Supreme Court case. In Shapiro v. Kentucky Bar, an '88 case, An attorney sought to send targeted mail to people facing home foreclosures, contrary to the then ABA rule that prohibited direct mail. The Supreme Court reversed the discipline, distinguishing in-person solicitation from targeted mail. Mail is like advertising. A client can throw away the letter. They are not subject to undue influence. Although the current ABA Model Rule 7.3 was the result after the Shapiro case, some states continued to tinker with the rules regarding targeted mail. Florida was one such state. It prohibited direct solicitation by mail for 30 days after an accident. In the case of Florida Bar versus Went For It, Inc., in 1993, the U.S. Supreme Court upheld that restriction as reasonable in time, manner, and place. The court noted that attorneys could inform disaster or accident victims in ways other than direct mail, by newspaper ads or billboards. So the prospective clients were not denied communication that they might find useful. The bar had conducted a study regarding the public's attitudes about such direct solicitation and had an interest in protecting the privacy of the victims and the reputation of members of the bar. This was also a consideration in the court's decision. Interestingly, there have been no further challenges to the prohibition of in-person solicitation by attorneys. But the U.S. Supreme Court did strike down such a prohibition applied to accountants in the case of Edenfield v. Fain in 1993. There, a CPA sought to personally solicit small business clients contrary to the stated board rule. The court reasoned that whether this personal solicitation may be prescribed depends upon whether the state's interests are substantial, whether the challenged regulation advances them in a direct and material way, and whether the extent of the restriction of protected speech is reasonable in proportion to the interests served. States' interests included preventing fraud and overreaching and protecting clients' privacy. The Supreme Court held that the state failed to show that a total ban advances these interests in a substantial way vis-a-vis business clients. The rule was found to be overbroad and unconstitutional as applied to CPA fame and business clients. Query whether there might be some business lawyers who might be justified in conducting in-person solicitation, or whether attorneys, who are simply slicker and faster talking than CPAs, will forever and in all settings be barred from personal solicitation. Please read Rules 7.4 regarding communicating specialized fields of practice, Rule 7.5 regarding firm names, and Rule 7.6 regarding political contributions. Thank you.